Good morning, everyone. My name's Howard Coombs. I'm the Deputy Director of the Center for International and Defense Policy. I'd like to highlight, before we start, to acknowledge the territory upon which Queen's University is situated is to recognize its longer history, one predating the establishment of the earliest European colonies. It is also to acknowledge this territory's significance for the indigenous peoples who lived and continue to live upon it and whose practices and spiritualities were tied to the land and continue to develop in relationship to the territory and its other inhabitants today. I'd like to welcome you to the conference day, but before we start, you will see today, as we proceed, the biographies of the people speaking in the sequential order shown to you on the slide, so we won't redo the biographies in total. And in the lower left-hand corner, as you look at it, is a QR code that allows you to access the program. I won't say that again because I'm not teaching any of my undergraduates in RMC. So the Center for International and Defense Policy, in concert with the Canadian Red Cross and Queen's Law, as well as the Canadian Forces Military Law Center, are delighted that you could attend the 2023 Ontario International Humanitarian Law Conference, focused upon international law in the Asia Pacific. Now, why do I say that? Because what is a conference without attendees? We wouldn't be able to have this today if you hadn't come. So thank you all for being here. The importance of the Asia Pacific region, its population, along with the complex security environment, rife with frictions, makes today's conference both timely and relevant. We hope that the expert discussion of international maritime and humanitarian law, Canadian contributions to regional security, and humanitarian and disaster relief interventions will prompt much introspection and debate, along with ideas for future research and discussion concerning humanitarianism in today's convoluted international setting. As we move on, I'd like to, we will roll into the speakers next. So I would like to introduce Dr. Sophie Rondeau, a legal expert from the Canadian Red Cross. Her full bio is there. I've listened to her speak before, and I know that you will be enthralled by what she has to say. I found it, every time I hear her speak, it is such a learning experience. I'd like to welcome Sophie to the podium. She is going to welcome you and then move into her international humanitarian law presentation.
Thank you very much, Howard. So I'm a legal expert, but not a technical expert. So bear with me as I try to use a clicker. Here you go. First slide, a big success. Thank you very much for the kind introduction, and thank you for being here with us today. Doing in-person events, it still is something that is a bit new, and we are very appreciative of having a moment to sit down together to discuss important issue, but also to network and actually build those communities in Canada to discuss important issues. This is one of the reasons why we took the Asia Pacific theme for this conference. Howard did mention the military strategic consideration, the security consideration, the economic impact of the region. But one of the reasons we use that topic, we refer to it, was because this is something that occupies a lot of our work in the humanitarian sector, in the military sector, in the political center. This is something that we talk about every day. So we thought for students, this might be the area where you'll be working, depending on your different capacities in political science or in law or international relations. We wanted you to hear from experts what it looks like for the landscape, because you will most probably be the ones making those decisions and working in that area. A few words very, very quickly about our team at the Red Cross. Just sharing that slide very quickly. At the Red Cross, we do IHL education, means we reach out to teachers in high school, in colleges, so they can actually implement notions of international humanitarian law and humanitarian consideration in their courses. but we also do training and strengthening capacity. So I have the chance of working very closely with the Canadian Armed Forces and the college in delivering training to the forces. So having a dialogue to bring to the table a military perspective with a humanitarian perspective. So when we say that training and education and prevention is key to humanitarian law, this is not just a statement for strategic plans. This is definitely the place where you have the tough discussion when you are, as I said, in a comfortable room, you have coffee, and you can actually discuss those tough issues. So for us, this is really a chance to do capacity strengthening for all of the actors in Canada. Of course, that work would not be as fruitful as it is if we didn't engage into humanitarian diplomacy and advocacy. So we engage with the government and the important stakeholders in Canada to push for a humanitarian agenda, but always listening to what the stakeholders and the partners are saying. We are a small but mighty team of 6 to 7 people. It's always in flux, and you have the chance to meet some of my colleagues and some of the people in our team. So we are very, very grateful to be here and to do this event. Here we go. I won't add a lot on what Howard already said about the context. Maybe I'll focus a little bit more on the IHL angle. So my job this morning is to give you a very brief intro to IHL. For some of you, it would just be a reminder, you know about that. For those of you who are not familiar with humanitarian law, that's going to give you the basic notions of what this body of law does and how it works. If I do a good job, in the next 30 minutes or so, you will have more questions than answers. That's the idea of providing a landscape. The context of the Asia-Pacific region is interesting when you talk about IHL because there's not an ongoing global armed conflict, but looking at IHL provides a tool to address the consideration that we mentioned. It's a complex environment, economic, security, military consideration. IHL provides one of the tools to actually address a situation of armed conflict when they happen. You'll see in the last slide of my presentation, I am looking at the various international and non-international armed conflict that could be happening in the region. The analysis is not the one of the Red Cross. You'll see it's from RULAC. It's an academic research center in Geneva, but this is to give you an example of the complexity of the landscape and the various situations that are ruled by IHL. So as I said, this is to give you all of the pieces so you can actually engage. And after I'm done with my presentation, I can sit down and be like you and enjoy the panel discussion and understand the complexity of this setting. So let's dive into it. Quickly, because you'll see that the Red Cross mandate is closely linked to the body of law that is IHL. That's the Red Cross movement. The International Committee of the Red Cross has a lead function or a conveyor function in situation of armed conflict. They have a specific mandate under the Geneva Convention. So IHL closely linked with RCRC, they have a legal mandate, and they're also highly operationals in areas of armed conflict. The Federation has a lead on other situations. They mobilize the power of humanity. So they mobilize all of 192 now national societies to actually intervene in cases of natural disasters, aid for refugee, and health. You can see, and you'll see when we do qualification of conflict in a few slides, this is not, it's simply formulated, very complex in its application. Situation of natural disaster may occur at the same time of armed conflict. This is why all the components of the movement are being mobilized to actually do what? To alleviate suffering wherever it is found. So the humanitarian mandate is at the heart of the work that we do. So if I talk about RCRC or national societies, you'll understand a little bit more what I'm talking about. Before we dive into IHL, very quickly, I want to share with you what the Canadian Red Cross does in the Asia Pacific region. And I'll also share one initiative from the RCRC, not necessarily diving into the content of those initiatives, but just to show you the type of action that is being done and the type of project. So the work of the Canadian Red Cross in the region is to support the growth of our sister national societies. So we're doing a lot of organizational development, increase disaster preparedness. So that's the big angle from the Canadian Red Cross. We do have an expertise in health, community resilience, and improve disasters risk management. Without going into too much details, if you're asking me questions, I'll have to rely on the notes in my slides because I'm not an operation person, but these are the various countries in the region where we are working with the national societies to actually address, as I said, mainly situation of disaster management and disaster relief. That's the kind of work that we are able to do as the Canadian Red Cross because we have the resources and we have the possibility of being deployed internationally in addition to working domestically. That's for the ICRC now, the International Committee of the Red Cross. There's a presence in the Asia Pacific region. It's pretty small, I'm sorry for that, but you do have some regional delegation in Suva, in Fiji, in New Delhi, in I think Bangkok and Jakarta. These are regional delegation, but they also have operational delegation in different area where there are more or less armed conflict being waged in the region. I just want to take 1 minute to give you one example of an initiative that has been done, and it brings together that element of very operational, being deployed in the field, but also engaging with the stakeholders. So we do it in Canada, but the ICRC is also doing it with the government, and to have a state position, to have discussion and forums where we can actually see how IHL applies in the field and for the state, because it's their language. IHL is a body of law that spells out the responsibility and the obligations of the state. So we need to engage with them. So in 2022, there was a regional consultation on international humanitarian law and cyber operation during armed conflict. You have the list of the countries that participated to that initiative. This is a public report, so you can have the findings, you can find it online. Without diving into the specific of it, these are the main takeaway of that report. And it also allows, I think mainly the reason why I'm sharing that with you is visibility for the region. So we'll go back to it, but the Geneva Convention date back to 1949, where Asia was not necessarily sitting at the table developing that body of law. So engaging with the actors in that region is something that is important. The focus that was taken by the ICRC at that time was cyber. Okay, now we're diving into, I'm doing good on time. We're diving into what is IHL. So just giving you a general briefer so you can refer to it. When you have a presentation by on maritime law, on the military component, you can link it back to that body of law that's IHL and understand why it will be considered, or it could be a useful tool as we unpack different situations. So international humanitarian law is one branch of public international law, just like refugee law, environmental law, law of the sea. It's one of the branch that you have. Public international law is a law of coordination. It's coordination between states. So they decide the treaty that they want to ratify and the type of law that they want to abide to. IHL is the main body of law that applies in situation of armed conflict. I'll be using a few Latin expressions, but not too much. Here's the first one. It's the lex specialis. It's a specific body of law that applies in situation of armed conflict. We'll see in one slide, human rights law apply at all times with some exception that rights could be suspended, but this is the main body of law that applies in armed conflict. I like that slide. I come back to it. I've been doing IHL for 20 years, and for me, that's the definition of IHL. That's my own personal definition. Humanitarian law, it's not just humanitarian. For me, it's a realistic, pessimistic body of law. You'll see on the next slide, international law prohibits resorting to war. So states do not have the possibility of using violence to resolve their conflict. That's an infringement upon the UN Charter. But they still do. And if we ignore that reality, suffering will be incurred and population will suffer from the effect of that situation. So we need a body of law that addresses even the worst situation of violence that humanity can encounter. That's why it's a balance between, yes, humanitarian consideration, but also keeping in mind the military necessity. That's the pessimistic but realistic. It needs to work with the people that are actually waging war. Otherwise, that body of law would no longer be relevant. It will be something that doesn't necessarily speak to the realities in the field. So keeping that balance of military necessity and humanitarian consideration is at the heart of international humanitarian law. I don't know why we keep this slide with all of those steps. I need to change it. Every time I do a conference, I say I should change it, but I haven't done it. So that's the second Latin maxim section. Jus ad bellum versus jus in bello. That's a distinction. The right, or it should say the prohibition to go to war, is embedded in the UN Charter. War is prohibited, and there's two exceptions: self-defense, and there's authorization of the Security Council. If you have a sibling, if you're married, you know that when a fight is starting, it's really hard to point the finger at who started the fight. Who's the one that actually violated the resort to violence to solve a conflict, and who's in self-defense. This is a body of law that's called jus ad bellum. Usually that slide, if I'm taking it back 2 or 3 years, very academic. Right now, we hear a lot about crime of aggression with the Ukraine and the Russian conflict. This is top of mind right now. But jus ad bellum is a body of law different than the body of IHL. Once we have an armed conflict, all the rules of IHL apply to all of the parties to armed conflict, whether or not they're the aggressor or the victim. Why? Because that's the only way to prevent suffering. That's the only way. So equality of belligerent is really, really key. And it's not denying the existence of the UN Charter, but it's actually addressing the situation of the law inside of the armed conflict while it's happening. That's why it's used in bello. You can use that with your student. That's the law that applies inside of the armed conflict. So that's it. Let's move on. Sources. If you do international law classes, you would be familiar with Article 38 of the Statute of ICJ, which is, for lack of other documents, the source of international public law. So you have treaty law, you have customary law, and you have general principle of international law. International tribunal and courts decision, as well as domestic legislation, do play a role as auxiliary means to determining norms and rules of public international law. It's the same for IHL. I've included the cadre de référence, the reference here for the Canadian context with the various legal references. I won't be going into too much detail. Now we can dive into it. If we look specifically at treaty law, the Geneva Conventions, which were adopted in 1949, we have kind of a slam dunk. Why? Because all of 196 states, members of the UN, have ratified the Geneva Convention. So there's no way to get around it. All of the rules that are contained in those 4 Geneva Conventions apply to all of the member states. That's a good news. Not so good news, although it's not that bad. They only apply in international armed conflict. We'll see it in a slide. That means between 2 states. It doesn't address non-international armed conflict where there's a non-state actor waging war against a state or many non-state actors fighting together. But I still have a rebuttal on this. There is one article. So that's usually I have my conventions with me. I don't have them with me, but it's a book. It's, I don't know, 400 articles. We have one article that's common to the 4 Geneva Convention. We call it Common Article 3, that we call it a convention in Convention en miniature, a mini convention. It's about 3/4 of a page, and it contains rules that apply to non-international armed conflict. If you follow me, that means that all of the states that ratify the Geneva Convention, which are all of the states at the UN, there are rules that they need to abide to legally for non-international armed conflict. Although it's a small article, it still captures a lot of the rules that needs to be respected in situations of armed conflict. We also have the additional protocol. If we come back to the context, 1949 was right after the Second World War. So the momentum for the international community to take action was definitely there. Everybody was shocked by the atrocities that have been committed. So 2 actions were taken, among others. First, to condemn the violator and to have accountability for people that committed war crimes. That's Nuremberg. But we also said, let's look ahead. Let's do something so this never happen again. So we're going to adopt conventions that address those situations of violence. So we were very much in a Second World War state versus state situation. 1977, the context is different. Although we are not denying the value of the Geneva Convention, it's not putting them aside. There was a consensus to actually add to the rules of the Geneva Convention for what? Well, to address concerns that were new in the 70s, decolonizing war, war of national liberation, you have the Vietnam War. So at that time, the international community reached a consensus and say, we need to have additional protocol to the Geneva Convention. The first one is to protect the victims in international armed conflict, so fleshing out the rules that we find in the 4 Geneva Convention, and the second additional protocol, fleshing out that common Article 3. We have a full protocol that now applies to non-international armed conflict. Good news, not so good news, not universally ratified. Let's see, 3/4 of the member states of the UN have ratified it, but still, it means we have a lot of legal standard to pull from when we are trying to engage with authority and we're trying to achieve our humanitarian mandate in different contexts of armed conflict. So that's the visual slide. If you're a visual learner like me, oh, there's so many steps on that slide. Let me just bear with me. Okay, so that's the qualification. You could see that as legal advisors, as IHL lawyers, we need to navigate that space a lot because it's not the same law that applies if it's an IAC, International Armed Conflict, or an IAC. So that's a recap of what I've just told you. International armed conflict, the use of armed forces between at least 2 states. IHL is applicable from the first resort to violence between the state, and you have the 4 Geneva Convention, additional protocol 1, if it has been ratified, and customary IHL. If you have a question about customary IHL, which I don't know, a lot of people don't usually have, you can come to me bilaterally. I can spend hours on this. This was one of the topic of my my thesis, but I won't dive into it. But it's a body of law that's very important in IHL. We do have a study that came out in 2005, captures 160 rules that are considered customary. But we will focus on treaty law for the matter of today. Non-international armed conflict is a conflict between a state and an armed group or 2 armed groups or more. IHL applicable under 2 conditions. There needs to be a certain threshold of violence and sufficient organized groups, in which case you trigger the application of Common Article 3, if you're following me, and additional Protocol 2 in addition to customary law. Other situation of violence, internal disturbances, tensions, riot, isolated, sporadic act of violence, that's the language we use in IHL. IHL will not be applicable, but human rights law is. Torture, discrimination, sexual violence, never acceptable in time of peace, in times of war, in times of sporadic violence. There is, in terms of using the force, the way that you conduct hostility only applies in situation of armed conflict. You don't necessarily want IHL to apply in time of peace. As I said, it's a pessimistic body of law. This is not necessarily the standard you want to have in a peace operation, peacekeeping operations. So this was simple, the first one. This is a slide that we created, and I'm sorry, it's in French. I didn't have the courage to translate it. This is what the current context is. So it could be very simple: IAC, NIAC, non-international armed conflict. This situation is complex, and I think that's going to be very interesting in hearing the Asia-Pacific region. There could be a situation like that where you have non-state armed group fighting against each other and other components. So this is the slide where you should have more questions than answers, but it kind of is giving you kind of a snapshot of the context in which we work, where yes, qualification of conflict is a straightforward exercise. Applying it in situation is something that requires a lot of work and a lot of technical expertise. So at all times, international human rights law and national law will apply. In situation of violence other than armed conflict, that applies. You have the reference to the UN Charter, and in armed conflict, you do have IHL. I want to flag very quickly, there are some rights that could be suspended and legally in context of armed conflict or national security concerns. Usually having a curfew is a limitation on your freedom of movement. That's an example that we use in armed conflict, but we've experienced it during the pandemic. That was the freedom of movement, freedom of association was limited. It was an infringement upon human rights, but it was legally acceptable. Why? For health reasons. In the case of an armed conflict, it's for security and safety reasons. They can be suspended. As I said, torture, discrimination, sexual violence is never acceptable. This is common sense, but it's also legal requirements. Overview of rules of IHL. I have visual to help you. Le Jet d'eau de Genève, Geneva law, rules that regulate the protection of people, mostly civilians, wounded, people no longer taking part in hostilities. You also have the Hague Law, that's the peace palace that you have there. These are the rules that regulate the use of force. So that's conduct of hostility, targeting, and whatnot. Person who are afforded protection, civilians, those who are not directly participating in hostilities. That includes men and women, children that have specific provision protecting them. For example, prohibition of recruitment and use of children in armed conflict, which is bigger than just recruitment. The wounded and the sick combatants are also protected by the body of law that is IHL, medical and religious personnel, and those who are deprived of their liberty, people being detained for security reasons or because they're taking part of hostilities. In all those cases, torture and cruel, inhumane, and degrading treatment is prohibited, especially for those who are deprived of liberty because they are in the control of an authority that can actually have influence on that. Protection of impartial humanitarian action. This is where the work of the Red Cross takes its full scope. This is also where the legal protection afforded to humanitarian action meets the operations. I won't read you the Security Council resolution adopted here, but impartial humanitarian action is protected under international law. This is not just an ask from civil society or for the NGO movement. That's an obligation for all the states to allow humanitarian action. So even in a theater of operation of an armed conflict, there is space that are protected. The whole combat area is protected for a civilian, and all of the exercise regarding targeting factors in the principle, and we'll come back to this, of distinction between combatant and civilian. So this is an obligation under international humanitarian law. As I said, remember, simple in its formulation, complex in its application. That's kind of the motto for IHL. I want to finish before we move on to the conflicts, to qualification of conflicts in the region. So coming back to Asia Pacific and leaving the floor to our panelists to actually dig into this, I want to briefly tell you about the limitation of means and method of warfare. So conduct of hostilities, if you're not familiar with. So the basic rule is the right of belligerent to adopt means of injuring the enemy is not limited. So you probably hear it. Even in wars, there's limit. Even in using weapons and using tactics, there are limits. That's what IHL does. First principle, that's a key principle. That's the element, distinction. You need, when you're actually conducting an attack that's governed under IHL, so in the context of an armed conflict, you need to distinguish between civilians and combatants. Only military objective and combatants are lawful targets. So the principle of distinction is key, and it's at the heart of that body of law. That's the only way you can actually wage a war in a way that saves humanity as much as possible, is if you apply the principle of distinction. Even if you apply the principle of distinction in conducting your attack, that attack must be proportional. So even if you're only targeting a military objective, it needs to be proportional. Proportional in what way? That echoes my definition of IHL. The anticipated military advantage should be not excessive when you're looking at the expected incidental civilian damages. So that's a big thing in IHL. Collateral damage, as we call it, is something that could be legally considered. There could be some damage to the civilian population. That's why you don't necessarily want IHL to apply in all the circumstances. Pessimistic, realistic body of law. But even if there's collateral damage, you need to apply the principle of distinction. You need your attack to be proportional. You need to meet those standards. Even if you apply the distinction, your attack is proportional, you still need to take precautions. Precautions in what? In assessing the legality of your targeting up to the very, very last minute, and also taking measures before and after to make sure that wounded and civilian populations have not been affected. This is in a nutshell. I took 3 minutes to tell you about targeting. When we teach it at the university, I know that's a 45-hour course. I'm looking at our colleagues from the JAG. That's their turf. That's what they do. Their whole career is looking at that. So this is definitely the baseline, but applying it in theater of operations is a big challenge. And this is also why at the Canadian Red Cross, we have the chance to engage with the military to go over those questions and to unpack them for as long as it needs to be unpacked, so we can understand the way that we work in the humanitarian field and the way that the military and the armed groups work, and how they can actually be empowered and educated on those norms. And we can also understand the reality of waging war in that context. Prohibition of use of sexual violence is a standard very important in IHL. Since I'm coming close to the end of the presentation, I won't go too far on this one. Okay, so very quickly, I'm going to take a few minutes, and I know this is opening it up. I mentioned to you, so usually the Red Cross, we don't qualify conflict. We don't do official analysis of conflict, but since we're doing Asia Pacific and the presentation won't be necessarily looking at IHL specifically, I thought it would be useful that I share with you analysis conduct by RULAC. RULAC is a research center at the Academy of Geneva of International Humanitarian Law, and they qualify armed conflict. We can sit down and we can disagree on the qualification of most of those conflict, but this is kind of a baseline to understand. And you'll have to bear with me. I would need my notes to qualify the various conflicts, so I'll go by memory, but this is just to show you the complexity of that regional landscape. So Tajikistan and Kyrgyzstan are involved in an armed conflict right now, as well as China and India. And we can share the link. You can see the analysis that's being made in the platform of the different armed conflicts. You also have Philippines, which is waging a number of non-international armed conflict with different actors. Azerbaijan and Pakistan are also involved in situation triggering the application of IHL. And you have India that also have non-international armed conflict with the Naxalite in the region there. And I finished with Myanmar. One of our panelists, Emma Fingler, will be touching on that. But there's also situation in Myanmar. And as I said, always in flux, and the analysis may differ from people, but there are regions where IHL may apply. And you can also look at that map and kind of compare it with where the ICRC is working in a different area. Things that are always in flux, but I thought this would be a useful tool for you to just get a big picture and actually engage into a discussion of saying, well, I'm not sure there's an armed conflict in India. That's the kind of conversation we want to have. IHL is really about applying kind of a in situ analysis. So this was just to give you something to ponder on. So thank you very much for your attention. I'm going to lead it back to Howard. If you have any questions for the time remaining, if not, if we don't have a lot of time for that, I really want our panelists to have most of the floor. So I'll be there after the event, and at the pause, we can do it bilaterally, but we have a little bit of time for a few questions. So I'm more than happy to hear you.
As Sophie said, we have time for questions. So I have the mic. I'll pass it to you to ask your question. Anybody like to start off? Well, Sophie, I have a question.
Oh, nice. I thought I solved everything. Everything was so clear.
In terms of IHL, if one side is applying, the other side is not, does the side that's applying IHL, can they change their behaviors? Should they change their behaviors?
They should definitely change their behavior. So unlike other international norms, IHL is not designed to protect states. Its interest is to protect human beings. So there is no principle of reciprocity. In the history of IHL, there was at one time, because it's a body of law that dates back many centuries, but the main reason to respect IHL, and that's more of the philosophical aspect, is for respect for oneself. If you're waging war, your own humanity kind of tells you that there are ways to do it because you want to be a positive citizen in your community after you've waged war. So respecting IHL allows you to remain that part of humanity in you. So there is no necessarily reciprocity. So to reach the aim of alleviating suffering and protecting human beings from the devastation, they're imperative. They're unconditional norms, and they must be respected by the party regardless whether the adversary respects it or not. That being said, very hard to manifest in practice. And this is why education on IHL is key, to be prepared to kind of have those notions embedded in the combatants before they are deployed, where all of the emotion and all the political consideration and the geopolitical context comes into play. There is no reciprocity in those rules. And this is one of the challenges of having a body of law that address. And I come back to it. I think IHL, all of the states ratify it. So we have a voice to actually push for that. And but thank you very much for your question.
Thank you. Anybody else?
Oh, that's a good question. So first, the Red Cross movement will not necessarily have an official position on use of force itself. That's use at bellum. So we really focus, our mandate is really around international humanitarian law, and use of force is a concept that we dabble into, but we won't have necessarily an official position. What I can say, if I can take the question back to the mandate that we have, impartial humanitarian action needs to be protected. We did mention that. So kind of blurring the line and instrumentalizing, intervening militarily to support a population is not something that kind of works within that framework. And we, from a humanitarian perspective, we are reluctant into engaging into those kind of discussion because it instrumentalizes work that has already been done, and it might trigger more conflict, more violence. So limiting the use of violence, and especially jeopardizing the mission of the Red Cross. So the only way that my colleagues in the fields are protected, and they work in the same theater of operation of other people, is with this. They have a Red Cross, they have a Red Crescent. So that's the only protection they have. It needs to be crystal clear to anybody that's intervening that their mandate is humanitarian. So when you dabble into military intervention, for whatever reason it is, we don't necessarily look at the reason. There's a possibility that the perception, and this is just a matter of perception, but perception is everything in situation of armed conflict, where the population, the line will be blurred, and this is something we try to refrain. And we offer a solution. We say, let the humanitarian actors actually do this. We are expert. We know our field. We've been deployed in the field. The national societies, it's their home. Like, they've been living there for their whole life. That's why we support them. We're not coming in with a solution. We're listening to them and saying, what do you need in your field? So that's a very humanitarian position. But thank you for asking. Thank you.
Is this working? Okay, awesome. Normally I'd leave this kind of question to the end, but I have to leave a little early today, so I want to ask it now. I'm just curious about sort of what a career in IHL would look like. So on the one hand, education-wise, like how you would go about transforming your bachelor education into one that prepares you for international law. And then second of all, like, in the case of the Red Cross, how do you actually, go about getting involved with that later on in your career? Thank you.
Thank you for your question. So there could be a short answer. Working in the humanitarian sector, I think there's two ways to look at it. So if you want to be actually in the field and being deployed, there's a lot of lawyers that are what we call delegates. So working in the field, it's actually being involved in the operation. You have roster, you can become a delegate for the International Committee of the Red Cross. At the Canadian Red Cross, we also have delegates that are being deployed. As I said, our main focus is help, but we have comms people, humanitarian diplomacy people. So usually we can share the link. We have like a roster of different opportunities that are coming up. Becoming a delegate for the ICRC is something that is very popular among people, but usually we have a good profile for Canadian students. Our unit at the Red Cross, you being here today for the conference and meeting this community in Canada, it's the first step in actually being an actor of change and seeing if there are possibilities to be involved. Of course, voluntary involvement service with the Canadian Red Cross is always welcome, although we don't have the capacity to have it within the IHL unit. We do have some interns. We offer internship when we have the capacity to do it. So there's many different options. My personal take on this is keep on talking to the people around you, not just expert. Talk to your peers. They're going to be your network of people you're going to be working with in your professional career. Attend conferences, read books, read blog posts, get published, and engage into the dialogue here and try to engage with different stakeholders. And usually, I don't know, that's what I did. I've been talking to one of my colleagues. I still don't know what I want to do when I grow up. So maybe I'm not the best person to kind of give you a path in life or where you want to be. But the way that I did it, I always followed working with people that I align in terms of value, in terms of work ethics, and saying yes to different opportunities and kind of engaging into something that speaks to you. That's kind of how I said. So you being in the room today, I think it's the right step in that direction. But thank you for your question. The main reason and for me, that's not Red Cross, although it might be the position as a researcher, it's the only body of law in international law that factors in an initial violation. So we realize if the UN Charter prohibits resorting to force, it means that one of the party violated the charter. So it's a body of law that exists within the context of a violation of a prior right. So for me, that's why it's kind of pessimistic. The best situation would be there be no war. And that's the solution that's provided by the UN Charter of resorting to peaceful means of resolving conflict. So it's already kind of a failure of the state. But also recognizing that this exists, for me, is very empowering. We're not going to put our head in the sand. We're going to say, this exists. So we need to put up our sleeves and we need to prevent suffering. Just saying that it doesn't exist and it's a violation of international law. So for me, that's the pessimistic, but also realistic, saying we need to acknowledge this this exists. But you're right. I think I made up the pessimistic qualification as I was getting very involved in my thesis.
Thank you very much for a really fantastic overview of IHL. My question relates to kind of building on my colleague here on thinking about impartial humanitarian action and then thinking about the Geneva additional protocols related to the protection of victims. If there are two states that have ratified the additional protocols that are engaging in an armed conflict, how does impartial humanitarian action factor into that? And can you speak a little bit more to that obligation? I'm not sure what the exact question is there, but I'm trying to understand how, if we could potentially bolster more protection for victims through combining those obligations under IHL, and what your take is on that, or if I've misunderstood something.
Not misunderstood. That question, I can take 1 minute to answer and we can take a couple of hours. That's a really good question. That interplay between non-state actors, so the Red Cross is a non-state actor that has like a focus, eagle vision on humanitarian focus, and working in an environment that's highly political. War is highly political and there are parties, and state being the bearer of the obligation under IHL is key to it. So kind of that interplay, I'll give you part of an answer that could be useful, and it's very specific to the Red Cross, but I think it will give you a piste de réflexion, ways to move forward on that. So in the Geneva Convention, so international armed conflict between two states, there's a specific role for the RCRC and the Red Cross, Red Crescent movement to actually intervene for humanitarian purposes. So there is a space that's carved out legally. There is a space that's carved out in operations, sometimes very challenging to implement, but there's an obligation, a specific one. It's the only body of law, the only organization that is embedded in the legal framework. The only one that I know of is the 1950 Convention on Refugees, but it's for a UN body. It's for UNHCR. So we're not a UN body, but we have that specific mandate because the state decided and recognized that this was needed and this needs to be taken care of by a whole body of law and a whole organization that can actually be invested. So of course, providing impartial humanitarian action, one of the modus operandi, the way of operating for the Red Cross, and that's also me making it up. This is not an official way of talking about our mandate. It's a sandwich approach. So very, very hands-on in the field, doing assistant work, doing protection work, being there with the population, but also top-down, working with governments, working with ministers, doing parliamentary testimonies, working on bills. That sandwich approach allows us to have a strong presence with the population, but also having a good reputation with the key stakeholders. So impartial neutral action is kind of in that sandwich. That's the sweet spot, or where we can actually do our work because we're recognized for being impartial, which means that we don't take sides. If you ask the Red Cross, you're either with me or you're against me. For more than 200 years, we had the same answer. For the Red Cross, I am with those who suffer, and this suffice. We go where the suffering is, and we engage in the same way with the different parties. Just to finish on that, for non-international armed conflict, we don't want to infringe on state sovereignty. It's within a state, so we have a right of initiative. So the Red Cross has a right to offer its services and actually engage. Usually, when that is triggered, states usually allow us to do this work, so we can engage into a confidential and bilateral dialogue with the authorities, but that's the legal framework around international and non-international armed conflict. But thank you for your question.
If you don't mind, I just add one more question to that. In cases where impartial humanitarian action or aid is frustrated, what are the most effective paths to make that happen? I'm thinking of population in Gaza. And I know there are humanitarian access points being opened and some paths forward, but limited, likely limited considering what is needed at this time. And I think we have and will see more of those situations in the future. How can IHL or the ICRC be a part of opening more effective and immediate avenues for impartial humanitarian aid, or maybe that just factors into the pessimistic nature of what you're referring to?
So 3 words, and then I can frame it. Persuasion, mobilization, and denunciation as a very last resort. Persuasion is part of always being there. So one example, you're deployed in the field and you're always present. You always have a presence. I haven't got into the details, but one of the work that the ICRC delegate do is protection work. They visit people deprived of their liberty and they monitor the conditions of detention and they make sure that they're of human treatment, but also that they don't disappear and whatnot. So that work needs, one visit is not that useful. 1,000 visits week after week after week, that's what's useful. So being present in the field and actually engaging and building a relationship with the stakeholder, confirming that our reputation as a humanitarian actor is valid, that's the way to do it. So the first thing is persuasion. You're trying to persuade the actors. We're not state, so we're just trying to push it with our expertise to persuade the actor to do the right thing. If that doesn't work, we rely on third parties that might have influence. We rely on on other people that are in our network to carry that message as well with us. So it's one front, it's one Red Cross. So we move forward to push a humanitarian agenda and we get on board people that actually support that message. That's where it dabbles into political, UN. As you probably know, the ICRC and the Federation has an observer status at the UN. So that's the next step. Denunciation is very rarely done by the Red Cross, but it's part of our toolbox. It's something that's possible. If there's nothing else to lose, if we don't have access to the victim, then we can resort to denunciation. We've learned in the past, and I think the example that I have in my career in the last 20 years is Myanmar. There was denunciation, but the cost of that was very, very high for the ICRC. And they realized that that took years to rebuild the trust afterwards. So denouncing is not necessarily the way. That means that the tough conversations are happening, but they're happening behind closed doors with whom? With the people that actually have an impact on the population. So the fact that I don't hear from it in Ottawa or in Montreal doesn't mean that it's not happening. It means that it's happening in a closed circuit, so that action can definitely move forward. That's the nature of the confidential dialogue. That's also why denunciation is not a means of operation that we rely too systematically, because we want to keep the access to the victims.
Thank you very much, Dr. Rondeau. Please join me in expressing our appreciation for a great presentation.